Welcome, everybody. We have an awesome day planned. And I've got some amazing news. Guess what? Well, I'm sure I'm going to have to share this twice. We have to be careful of our words now. Yep, we can't say certain things anymore. Can anybody guess why? Put in comments why you would think that I can't use certain words anymore. Yep, it's a big deal. Big dang deal. Oh my gosh, y'all. While we're waiting for that, I want to apologize. We had our times mixed up, and that is on us, and we apologize. We are human. We make mistakes too. Monetized, baby. We are now monetized. It happened in 24 hours. I was like, are you kidding me? In 24 hours, we of filling out the application, we got monetized. I was shocked. Absolutely shocked. Good morning.
Is the cat here with you?
I don't know where she is. Is that Miss Kathy?
It is Kathy.
Miss Kathy, come here. Miss Kathy, how are you? Kitty, kitty. Sorry for the bang. Also, I want to share the kitten is back to her normal self. She survived. By the way, Miss Kathy, we're monetized. Oh, Sensei, get her out of here. Ooh, I almost lost the entire feed. That tail on that lab is insane. Uh-huh. Sensei, out. Sensei, go. Go, go, go. Oh, I know that's a little chaos. Okay. A dear friend of ours showed up, and my dog loves her because she brings puppy cups all the time. And that tail is dangerous when you have cords. She has unplugged my lives. Yes, I know. Thank you, Miss Toxic Orchid. Thank you, Miss C. Morales. I am so excited. So excited. Yes, we can. And I don't know how to do that. Okay, you Miss Kevin, you got all the little pop-ups. I'm I'm out. My fingers are out of the pot. So we are able to accept super chats. We are in the process. I could do it today. Sorry, interpreter. My bad. I am, along with Miss Kevin, getting ready to set up the levels for our monthly memberships. They will start at $1.99. So we wanted to keep it affordable, but we're also trying to set up what happens and all of that. Oh, thanks for lurking. I'm sorry you're not feeling well, Miss Toxic Orchid. So give us a little day or so for us to go in and set everything up, because what happens is once it's set up, you can't change that. So we're making sure we're doing what we need to do. But the first person to super chat gets a blessing from me. So anyway, I need to see how that works. I need to see if it works. I don't know. We'll see. With that, the Alec Baldwin schedule, they are in court at, I think it's 8:30 their time every day. So we'll be on for that. Tomorrow we will not be on unless something happens, and I'll be on by myself. I have to go to San Angelo, um, Texas, because I am starting college again, and I have to go take care of that stuff. So it's crazy. It's crazy, crazy time for us. I want to introduce to you who do not know of our interpreter. Her name is Miss Diane. She will be with us when available, hopefully more often than not. But when she has another job, she will have to go take care of that. But also, my first sponsor has been so fabulous, and I want to bless them. So I'm going to run a commercial for them. But if you're looking for a really smooth, good tasting coffee that's not bitter, that is just fabulous, fresh roasted, ground or whole bean, this is who you need to call. Hey y'all, I am so excited we have our very first sponsor and I'm wearing this hat to honor them. Who is it? Well, it's coffee, my favorite thing. This coffee is from Hitchman Homestead Coffee. This is the Shooter Shack Coffee Pioneer Nicaraguan Roast. This coffee is so delicious, y'all. It is so smooth. It does not leave a chemical taste on the back of the tongue. It's not overly bitter. And I have to tell you, it is my favorite. And I am now getting rid of all my other coffee. I kid you not. They have a monthly subscription available. You get 4 12-ounce bag a month, either whole beaned or ground. And then you can also get a Keurig option as well. The other thing they have is wonderful gift boxes that you can send to your loved ones. So you want to support a fabulous home business and people here in the Hill Country, go to hitchmanhomestead.com and let them know I sent you and grab yourself some of the best tasting coffee we have here in Texas Hill Country. It is the best coffee, y'all. That's all I'm drinking. Also, I have a lot of comments and questions on several different social media platforms about my makeup. I did a live this morning. You can go and watch that. So, what we're going to do now is we're going to go and join the Alec Baldwin Motion Hearing and Void Dyer. And that's a pre-trial motions and void dyer. So let me add the screen. I'm trying to. We have new settings for the interpreter and myself, so I've got to change how I do things a little. Okay, and here we go.
The defense team what was going on with the court reporter, and it says, this is from Sarah Clark. For the avoidance of doubt, Summer Green is a member of the defense team who will provide the defense with real time and transcripts so as to avoid burdening the court staff with requests for records. So it does not sound that she is going to be the official record.
Understood, John.
So thank you so much, but you're going to have to move.
I'm already stopping it. For those who don't know, you are allowed to have someone like another court reporter. They come in on your side if you're the defense and do your own court reporting. However, it's not a part of the official record, and they can't be sitting in the courtroom where the court reporter is. So it's very, very important for all that to be worked out, just so y'all know what's going on.
There, that's what she said. So she's asking for real time. That's up to the defense whether they're going to give you real time.
So I think both sides are using Ms. Green. When we realized that she'd been hired by the defense, we wanted the real time also, just to even the instruments here. If Ms. Green needs a place to sit, she's welcome to sit over here. And I agree with the court. The official record is
that means that all the exhibits go through Faith.
Absolutely.
All right. So at the end of the day, she collects the exhibits. I'm sorry, David. All right. So if you don't mind moving, this is optics, and that's how it's going to be. I'm sorry. And then so all right, I'll let you do it today, but tomorrow, yes. Okay. All right, so let me hear from you all on what I'm prepared.
Sorry, how's the sound? I can do that. There's a lot of wind, air conditioning noise. It's real crappy audio in that room. Nothing I can do about it. Let me crank it. This is full spectrum. Okay? Let me know if it needs to go down. Oh, didn't mean to do that. There we go.
So, all right, I'll let you do it today, but tomorrow, yes, okay. All right, so let me hear from you all on what I'm prepared to do is hear the motion on excluding late filed witnesses and then going into the motions in limine, and we can do state defense. What do you all want to do?
That's fine with the defense. I think many of the motions hopefully will be far shorter, and some of these issues, I think, have somewhat been dealt with the briefing, because as much time today as can be spent on things to make sure we have an orderly and good trial, I think are helpful. Some of those were raised in the bills and some were not, so that's a fine system, and we're going to hope, at least on the defense side, to move quicker.
Okay. All right, so let's take up okay, State of New Mexico's amended expedited motion to exclude defense witnesses Ryan Winterstern and Christopher Zook. You can use the lectern or you can, yes.
You might want to turn that microphone on.
And just so you know, so everybody knows, if you have a green light, that means your microphone's on, and if you don't want anybody to hear what you're saying, you want to turn that off.
May I proceed, Your Honor?
Yes.
Your Honor, the state filed this motion on June 26, 2024, after the defense disclosed on June 24th a witness by the name of Ryan Winterstern, and I understand he is one of the producers of this film. Mr. Winterstern had not been disclosed by the defense on any of their witness lists prior to June 24th. And while they argue that the state had Mr. Winterstern on its witness list in the Hannah Gutierrez trial, we would respectfully submit that that's a different issue. So here, the state did not have Mr. Winterstern as a witness. And so we understand that the defense is claiming that the reason they added him is because the state at the last minute added this producer theory. However, as the court, I think, noted in one of the hearings that we had previously, this producer issue was known to the defense. And in fact, during the grand jury presentation, and it begins at page 186 of the grand jury transcript, Ms. Morrissey questions the state's expert, Brian Carpenter, about Mr. Baldwin's role as a producer. And so this is not something that was new to the defense. Under State versus Lemire and State versus Sanders, the state is asking the court to exclude Mr. Winterstern because, number one, we have not been provided with the statement that he is going to be making or has made. We didn't have an opportunity to do a pretrial interview of Mr. Winterstern. So as it relates to this case, the state has no idea what he is going to be testifying about or any previous statements that he made relating to this particular case. Setting Gutierrez trial aside, the issue is, what is he going to say in this case? And because of the late nature of this disclosure, we'd ask that the court exclude Mr. Winterstern. With regard to Mr. Zook, now, while the defense is right, the state did not request pretrial interviews of law enforcement witnesses. They were made available. Mr. Zook was set for a pretrial interview, but apparently he has left the sheriff's department. So the defense canceled his subpoena and did not proceed with the pretrial interview. So he was not interviewed. We would respectfully ask that because of the fact that the state has not interviewed these witnesses and particularly Mr. Winterstern, was disclosed so late in the game, we ask that the court exclude these witnesses. And unless the court has any questions, Your Honor, we rest on the motion.
The court does not. Thank you.
Thank you.
Good morning, Your Honor.
She's easy to listen to, but
So we'll start first with
looks like a
Christopher
daughter.
Zook. As the state has already conceded, the state did not actually request a pretrial interview of Mr. Zook. It is something that they do have to request. The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy, they could come if they wanted to, but it was not something that they requested. And if the party does not request the interview, then it is deemed waived. And at any point, they had an opportunity to do so. I do have an exhibit to provide to the court. I also have a copy for the state. And so I do have an exhibit A, which is to this motion, if I may approach, Your Honor. And what I've presented the court with is a series of emails that were exchanged between the parties. And these begin with the request that the state made for witness interviews in this case. And as the court can see, and as the state has already conceded, Mr. Zook is absent from their request. Now,
I have to say thank you, Miss Kevin. We have our first super chat. Oh my God, it worked. Oh, okay. Y'all know what to do. Send the love. Just so you know, a portion of all super chats will be divided between myself and the interpreter and my mod manager. We thank you for the love. Oh my God, I'm going to cry. We're monetized.
the reason we've included these additional emails as well is because there were multiple occasions on which the defense actually asked the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor. And we canceled the pretrial interview that we had set for our own benefit for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him. Additionally, with respect to Ryan Winterstern, it is somewhat ironic that in their motion, the state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage, when really what we have here is that type of behavior on the part of the state. And one of the ways that we see this is that with respect to the initial filings before there was a dismissal in this case, when the case was originally brought before the court against Mr. Baldwin, originally it had been clear that the previous prosecution team had intended to produce and to pursue a theory that involved liability based on a producer theory on Mr. Baldwin's alleged role as a producer. Based on that, we also then had a conversation with the new prosecution when they took over through Ms. Morrissey. And a conversation was had about the producer theory. And that was gone into in-depth and private conversations, at which point in time, Ms. Morrissey indicated that she did not believe that that had that could hold any water, that it was a viable theory. Later, certainly there was the grand jury presentation. Now, there was really not much of anything related to Mr. Baldwin being a producer. They didn't call anyone who was on the set. There were a number of different producers. I believe it was 6 different producers who were actually on the Rust set. They didn't call a single one to testify. And so it was not clear to the defense. And the fact that it was unclear to the defense is apparent in the fact that we have an additional exhibit, Your Honor, if I may approach.
Just FYI, if you notice a lighting change in your of the courtroom feed it to them.
And the exhibit that I've just now handed to the court, which would be then Exhibit B to this response, is an email correspondence between, again, the state and the defense, wherein, as the court can see, and I think the court will have to flip to the back page to see the beginning of the chain. And so on November 1st of 2023, the defense inquires and says, your target notice identifies 2 involuntary manslaughter charges on which you will be presenting information to the grand jury. We then proceed to ask that in order to ensure that the alert letter that we submit actually is efficient, that we don't waste everyone's time, that they identify the 2 theories that they're going to be proceeding on. The state, through Ms. Morrissey, then responded, basically just reciting the statute. We then asked and followed up on that to say, we assume that the producer theory is not going to have merit, and so you're not proceeding under that theory. There was no response. The state easily could have responded, could have let us know. They knew where our mind was. They knew that we were thinking, because of the prior conversations that we had had with Ms. Morrissey, that this was not a theory that they were going to proceed under. Additionally, Your Honor, with respect to the witnesses that they've listed in the actual case itself, and this again goes beyond just the grand jury. In the case itself, the state has not listed a single one of the producers who were on the Rust film, not a single one. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be on this film, what responsibilities he would have. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set. So we sought, after the state had then disclosed, basically for the first time to us, their intent to proceed under this additional theory through some of the motion practice when we filed a motion related to one of their witnesses. They then first identified that they were going to move under this new theory. So we then, just a matter of days later, added Mr. Winterstern to the witness list, and it was for the first time. But this was because the defense was not on notice that they had intended to pursue this theory. And he was not on the witness list to try to gain some kind of tactical advantage. It was because he wasn't relevant due to anything previously that we understood the case to be about, which was, again, according to the indictment as well, it specifically lists the date of being October 21st, 2021. It does not list a series of dates. It doesn't list the length of time that Mr. Baldwin was on set. It lists one particular date. And so Mr. Winterstern was not relevant to the defense theory at that time. However, now we have added Mr. Winterstern, and the state cannot claim prejudice because Mr. Winterstern was a witness in Hannah's trial, and I'm almost finished, Your Honor. But not only that, he was the state's witness, and they did conduct a pretrial interview of Mr. Winterstern. And during that pretrial interview, it was actually asked by Ms. Morrissey what Mr. Winterstern's role was as a producer.
When was this pretrial interview?
This pretrial interview, Your Honor, that I have was January 8th of 2024. And so January 8th of 2024, he was asked a number of questions about his role as a producer by Ms. Morrissey. Ms. Morrissey also asked Mr. Winterstern about other producers' roles. Ms. Morrissey also asked about Alec Baldwin's role as a producer on set. And this is someone who would have personal knowledge of that, unlike any of the other witnesses that the state is calling to try to make out this producer theory. So there is zero prejudice to the state because everything that we would be going into in the trial has already been covered by Ms. Morrissey in their own pretrial interview for a witness whom they called in the previous trial. And so we understand that they're now trying to claim prejudice, but it's because that they know that this sinks their claim and that this is a much more appropriate witness than any of the 3 whom they've listed to try to go after Mr. Baldwin on this producer theory. So we ask, Judge, we are just asking for basic fairness and due process. There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Thank you. Reply?
Yes, Your Honor. Your Honor, the issue is the court issued a scheduling order in this case, not in the Gutierrez case, in this case. The court set deadlines for pretrial interviews. It set deadline for witness disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case, because in Gutierrez, he was listed as a witness for the state. In this case, the defense is.
Okay, guys, I don't know what the heck just happened. We just lost this screen. So let me try and bring it, move there back. Let me move it. I don't know what happened. I don't know what happened, y'all. This is actually a good time for a break. Give my interpreter a little bit of a break. Usually they sign for 15 on, 15 off. So with that, we're going to give her a break. We might lighten you up a little bit, babe, if possible. I still don't know what happened to that feed. I'm going to remove it. I'm going to add it back on state. There we go. Yay. Oh, that scared me. I got to cover up that section. So, for those of you who don't know, we are now monetized. We are now monetized. Oh my gosh, I am so excited. This has been a fast and feverish journey, and I am so excited. And it has been a huge, there it is, that's why. It's been a huge blessing. We are monetized, and I got the notification Saturday that we had hit, or Sunday morning actually, that we had hit the number of views, hours, we hit the subscriptions, we hit all the targets for monetization. I was not prepared to be monetized this morning. When you fill out an application to be monetized, it can take up to 2 months. And the fact that we were approved in 24 hours, I'm just mind blown. So, with that, let me explain basically what's happening here in short terms. This can be a little boring and a little overwhelming. What's happening is that they have a motion. The state has put forth a motion to keep 2 witnesses out of trial because they don't feel the defense gave them enough warning. The problem with that is, they were told they were going to be witnesses per the defense side of the story, and they chose not to interview them. They chose not to do anything. So that's on them. And I have to tell you, the prosecutor looks awfully a lot like the judge. I wonder if they're family. That would be a conflict if they were, so they couldn't be. But anyway, we're going to keep listening. I hear it gets a little spicy.
Calling him. The state has no idea what he is going to be testifying about. The state has not been given any prior statements as it relates to this case. And as the court can see, Your Honor, what we have here is by this email is that the defense was put on notice, and they call it a producer theory. It's really not an independent theory of liability. What this evidence goes to, it goes to Mr. Baldwin's knowledge that his conduct on set was reckless, and it was in essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on sets, what his responsibilities are. And so, as we'll argue in the 404 or the intrinsic evidence motion, this particular type of evidence is germane to the defendant's recklessness in order for the state to prove the involuntary manslaughter. They cannot claim that this is a new theory. As I noted, Your Honor, page 186 to 187 of the grand jury transcript, which was attached to the state's June 21st, 2024 response to the defendant's motion to file a supplemental brief, Ms. Morrissey goes into great detail with Mr. Carpenter, the state's expert, about Mr. Baldwin's role as a producer, his responsibilities as a producer. Mr. Winterstern, from what we understand, has very little producer experience, but nevertheless, we would argue to the court, Your Honor, is what is he going to be testifying to in this case? The state has no idea. That Ms. Morrissey spoke to him in the context of the Gutierrez trial is irrelevant to the court's analysis in this case. Under Lemire and under Sanders, and in Sanders, it's 1994 New Mexico Supreme Court 43 at paragraph 26. The court noted a defendant's right to present evidence on his own behalf is subject to compliance with established rules of procedure and evidence designed to assure both fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well. And so we'd ask that the court exclude Mr. Winterstern. Thank you.
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr., well, first with respect to both of them, I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Wingerstein available for a pretrial interview. And with respect to Zook, I'm not quite sure now. They're saying they want an interview. All right. Is that a problem for you?
You can confer with the state and work out the issue.
All right. Thank you. All right. Remember, I believe it's 10 minutes aside, half an hour for lunch. So I'll start with one of these. All right, state's motion in limine to exclude evidence or separate civil suits against defendant and or Rust Productions.
I am going to do this because a lot of people don't understand what was just said. This is going to be a description or an example of what motion in limine is. It's limine. It's Latin, which means on the threshold. At the jury's start. Oh, that should have been silence. Or at the start. So a motion in limine, and we can interpreter. A motion in limine is a motion made to the court before a jury has been selected in either civil or criminal law. So these are all the things that they're going to use to decide what actually can come into court. I'll get it back. What actually can come into court or what may stay out of court. It's very, very important that go to a different link. So the motion in limine is very, 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 very important. It is basically setting up the rules of the game. What we're going to do a little bit. So this is the game plan. Thank you so much, Haley. Thank you so much. Oh my gosh. Everybody was lurking in RA this morning. Oh my gosh, that's awesome. Okay, let me share screen and let's get back into it.
Preclude improper.
Let me scoot. Okay. Because this is pre-recorded, I can jump around.
require an orderly trial.
And yes, Your Honor, I think this is a good place to start today, because this is sort of my main issue throughout the day and what I'm going to ask to address at various points. And that's why I'm going to keep my remarks so brief on all my motions, because hopefully the court will give me the courtesy of a few more minutes when I need at the end. But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places, that's their sort of strongest response, misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation where the prosecutor says, I, of course, have the burden of proof. It never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state in this country. So the reason that I had to make this motion is because in reviewing some of the trial, and I haven't been able to get through every bit of it that I want to on this subject, but it's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made a motion like this before, but it's objection. This witness doesn't know that. Objection. They don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill, which is constantly, every single witness, they'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on. And they would ask another question about the chronology. And they say, well, where's Miss Hutchins? She's in the helicopter. And so, this is, it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very serious to do that as a prosecutor.
Thank you, Haley.
And so eventually the court at some point stopped Miss Morrissey from doing the coaching, speaking objections. And then Miss Morrissey began, every time her name was mentioned in a question, she began to stand up and say, well, I'm being talked about in this question. And she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. But my request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer can approach. But otherwise, none of those tactics and devices should be used at this trial. We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Response.
I find it interesting. They set up the grounds on how they're going to object and what the court will and will not allow. Rarely does it happen. What he just said is the way it's supposed to be. In other words, to make everything he said into a very simple phrase. 3 words. No talking. Objection. That's it. Here we go.
Thank you, Your Honor. Your Honor, I think we can agree on one thing. Absolutely, without a doubt, and that's beyond dispute, the state has the burden. And the state cannot shift that burden to the defendant. Absolutely agree. However, there are those limited circumstances where the state is given latitude with regard to countering defendant's arguments. For example, the defendant comes in and, as the court has heard, presents argument that somehow somebody modified this firearm. Where is that evidence? The state should be allowed, and it has been allowed, and in fact, in State versus Aguayo, which is cited in the motion, 1992, New Mexico Court of Appeals 124, the courts have allowed the prosecution to argue that the defense didn't present witnesses to support their defense theory. But the state has the burden. There's no question about that. So we would ask that the court give the state some latitude with regard to responding to defendant's arguments. And I can guarantee you, we will not, the state will not, under any circumstances, shift the burden to the defendant, because that's improper and it will not happen. With regard to vouching for opinion or for witnesses, I agree it is improper to vouch for a witness's credibility. But there are circumstances, Your Honor, where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper, absolutely agree. But if it's based on evidence that a witness testified to X and there's corroborating evidence of X, the state is allowed and should be allowed to argue to the jury that this witness has testified truthfully based on the evidence. And finally, part of this, during closing argument, Your Honor. Yes, no, not during the trial. With regard to coaching witnesses, Your Honor, which is the last part of this motion, I agree as well. A prosecutor must not coach a witness, particularly must not coach a witness to testify falsely or to phrase the witness's testimony. However, it is absolutely proper for the prosecution to meet with witnesses, to prepare to testify. The defense has taken the position, I believe, that any sort of preparation with witnesses is improper. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. That the prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare for their testimony is completely proper. And we'd ask that the court not allow the defense to comment on that as being improper. Thank you.
Anything else?
No, Your Honor.
All right. Well, I have to say, I don't like these kind of motions because I'm not going to be bound by it during trial where someone shows me an order and says, this is what I said. I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say objection, blah, 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 and then wait for me to say to come up. You're going to come up. And this happened in the Hannah Gutierrez trial. So.
Yeah, I just point of clarification. I don't have any intention of approaching during the trial other than the rarest of circumstances.
No. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
Okay, I have to internalize this. I've never had a trial conducted that way, so I would ask to potentially address this issue. I mean, I don't think the defense or anything that I've done would necessitate changing the rules. At least I would ask that
this is a court can do what they want with respect to objections, and this is what I'm going to rule. So I'm trying to the sides have been contentious with one another. I think that you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and or make some argument to try to influence the jury. And if you're going to object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
And may I just approach for just a second? So I'm glad I saved my rebuttal because I do want to address this issue, Your Honor. What I would ask and urge the court, because I think that this system could disrupt the ability to cross-examine and it disrupt the defense. It is not, as I think the court will acknowledge, it is true, the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure. Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us, at least, if after the first witness, even, the court wants to revert to what they did later on in the Hannah Gutierrez retrial. But I can tell the court I've tried many, many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way. And then the court can, like this, and not hear from me further on this issue. Thank you.
I'm not going to change my mind. I can see what I want to do is I want to start with you all getting the lay of the land. And I'm going to be in control of the courtroom. So this is what I'm going to do. I'm sorry that you haven't experienced this because it can happen and it does happen. So that's what I'm going to do. If you all seem to be doing well and you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay? All right. So,
we're going to go to break. Miss Diane is getting some questions. I'm going to turn her voice on, put her up side by side. All right. And that will give you a little bit of a break. You ready for one? So you can voice and sign at the same time if you want, whatever you want to do.
I
Some
can,
people are very concerned about some of the words. So let's see. Here we go. Miss Dog Lover. Oh, wrong one. Come on, scroll up. Would it not be easier for the interpreter if they had shortcuts to court words like the word you just said, meaning motion and limine? Okay.
well, that would depend. Now, as this trial continues, we will develop the shortcuts like motion eliminate. But when they're first used, it doesn't work that way because I could just throw out initials, but you wouldn't know what they meant. Those who are deaf would not know what they meant. So in the beginning, you always have to do some finger spelling or like the emotion. So it just depends really. But as we continue, you will see, thankfully, shortcuts.
So a lot of deaf people do not know court verbiage. And that's one cool thing about having the interpreter. It gives them a place to learn. I mean, this is part educational, part fun. So motion and limine is signed differently depending on the interpreter. That's what interpretation means. It's not a transliteration. So when you go from English to Spanish, you're not really interpreters. You're transcribing. You're taking it from one language to another, correct, Miss Diane?
Right.
So with the deaf and ASL, it's more conceptual. It's an interpretation of what's being said. So, Miss Diane, please sign motion and limine.
I would be from now on, I would do MI because we've discussed it. And I would say it would be here as well. Now, if they're just talking about emotion, it's motion.
You're presenting something. A lot of times in sign language, it's not necessarily the exact word, but it is a synonym. And if there isn't a synonym, you can use an anonym or the opposite of to be able to communicate what's going on. So, I'm presenting a motion and limine. I know what that means. So the first time we use it, you saw I pulled up and read the definition
Does it
because,
mean get rid of motion?
huh?
Does motion eliminate mean to get rid of a motion? I don't know.
Okay, motion and limine is basically a way of setting up the rules,
Okay.
or you are agreeing upon how you're going to do something prior to jury selection. Meaning, perfect example, some judges do not like when a lawyer says, objection, that was leading the witness. As you saw with the Karen Reed trial, they set up a rule, motion. Objection. Objection. And then the judge would say, yes or no. They may overrule or they may sustain. So in sign language, if I was interpreting, overrule means I'm permitting it. Abstain, not permitting. But I'm not a court or national interpreter. That's Miss Diane. But that's a perfect example of sign differences. But they're setting up the game plan. Motion and limine. We're making a decision how we're going to do this prior to jury selection. That's the best way this layman can interpret that.
Yeah, and it's still the easiest is to go MI,
Thank
motion, eliminate, because I don't have enough time to put in there. They're setting up the rules before the jury comes or is selected. There's just not enough time for all of that. Now, at the very beginning, I mean, even 10 minutes before, I mean, we can look at words that were used maybe the day before and give some signs for them so that those who are watching know what that means. That MI means it's motion, set up, decide rules. It's just not enough time. At least for this interpreter.
No, there is definitely not enough time. It is very fast. And in fact, this pace of talking right now is very comfortable. But tomorrow, or I'm sorry, excuse me, Wednesday, that may change. I know this attorney does not like a fast paced speaking. She has slowed them down before. So that is a good question. Okay, another question. If we're going to follow a Karen Reed case again, if it gets there, we will. How boring is it to interpret the judge, if any? Joke.
The judge has the last word. Like she said, it's her courtroom. So really, I don't look at any judge as boring because whatever they say is important.
Yeah. Miss Diane did not interpret the first trial.
Oh, it'll be really interesting for me.
So it's going to be all new for you.
Yes.
But some of them talked about it like this fast. So what will happen is if they are talking way too fast, I will slow it down a notch. And then when another person's talking and they're more comfortable, I'll put it back. So I will be playing with the speed. I made a suggestion for the Scouter. He's command, meaning you can put Diane, and there would come a description of the word. We actually, funny you should say that. I are one of our mods. I don't want to say anything just yet who, but I'm he, she is going to be getting me some micro mini PCs. And so I will have multiple computers running. I will have a switchboard like Mr. RA, and I will be able to pop up and program that. But right now I can't. Sorry. But the thing is, this is far better than nothing. And Diane, have you ever seen this being done before?
I'm thinking. No, not even with, and I think of the O.J. Simpson trial, how big that was, and the closed captioning on it they would run sometime was like horrible. It was just like, it made no sense. I mean, somebody was not in their right mind when they were closed captioning that. But no, I've seen church services with the big preachers, and then they stopped doing that. So I've never seen it before.
The thing is, it's like even with the hurricane coming up to the south, I live in Texas, and I was excited because at first I saw an interpreter in the window, and then the camera zoomed in onto the uh, governor or mayor, and the interpreter was no longer in screen. Why do you have it if you don't show it? You're being following the law by having them there, but you're not being inclusive by getting them off the screen. So, if you see me looking more down instead of up, is because I sometimes need the interpreter. For those who don't know, I am fully deaf without my hearing aids. I grew up hearing. I'm able to speak clearly, obviously, but I can't hear anything without hearing aids. And even with hearing aids, it's limited. About the only time I can really hear is when I'm running it through a soundboard. So, anyway, thank you for the comments. We have, yes, we are working on this. This is growing. This is groundbreaking. Nobody else in YouTube is doing this. So if you know anybody who's deaf or hard of hearing who knows sign language, please share. I will start eventually, and really eventually, adding new content. But right now, this is where we are. And I may not have Miss Di every day due to her work schedule, but when she's not busy, she will be here. All right, back to court. Yay! We got to get this done. There we go.
I don't know I basically didn't really rule, except that I'm in control of the courtroom. All right, thank you.
Yes.
All right, next up is state's motion in limine 2 to exclude UNM hospital records of Ms. Hutchins' medical treatment.
Your Honor, we have no present intention of admitting this exhibit. I don't think there's any grounds to exclude it based on redactions, but this case isn't about the medical issues of Ms. Hutchins, and we're going to address these issues in another bill.
What is the bottom line? You are no objection?
No objection, Your Honor.
All right, no objection. I'll just write this down. All right, so the motion is granted. All right, defendant's motion limine number 2 to preclude inadmissible character and prior evidence and statements unrelated to the events of October 21, 2021.
Good morning, Your Honor. It's nice to finally see you in person. Thank you. So I'll be brief. You just heard Ms. Johnson, in response to our arguments about the civil suits, say the civil cases are about October 6th to October 21st, the whole negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore on set. He cussed. And therefore, what? He committed homicide? Mr. Baldwin pointed the gun earlier or rushed people earlier. And therefore, on October 21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity evidence that must be excluded, Your Honor. The state cites 3 cases about this. The first one, all of them illustrate it, but the first one illustrates it best. The US v. Reggio case. They say Reggio was a commercial trucking driver, and the state was allowed to introduce evidence of what he did before the commercial trucking accident that he was involved in. But when you look at the case, what actually happened was Reggio had a medical condition. His doctor diagnosed him with it. He went and he applied for his commercial trucking license, and he denied having the physical condition. He knew that condition made it unsafe for him to drive. He got his license, procured by that lie. He drove, he got in an accident, and someone died. And he was charged with involuntary manslaughter based on an unlawful act that he committed before. What was that unlawful act? He was driving knowing that he wasn't physically qualified. That was the predicate act. So the state said, we're going to admit evidence of that predicate act. He lied to get his commercial trucking license. And that's going to show, A, the predicate act. It's also going to show he knew it was dangerous for him to drive. And they were going to bring the doctor in there to say so. That's not at all what's happening here. Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite, starting with Reggio, have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th. And he knew it was dangerous to do what he was doing, yet he continued to act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. No one was injured because he swore at someone on the 16th or threw a gun on the ground on the 16th. They're trying to use it to show propensity. Reckless before, reckless now. They cite 2 other cases, the Coughlin-Lambert cases. Coughlin, they say, the court allowed the government to introduce evidence of his prior athletic activities when he had submitted a victim's compensation claim after being injured at 9/11. The state says, see, look, prior activities, case now about a fraudulent claim, 9/11. But the fraudulent claim charge against him was that he wasn't actually injured at 9/11 as severely as he said he was, because look at, he's running around, he's an athlete. He's clearly not injured. So it had nothing to do with propensity, it had nothing to do with he's a bad guy and therefore he committed fraud on the victim's compensation fund. It was directly relevant to it. Same with the Lambert case. It's a bank robbery case. The defendant was talking about robbing a bank before, planning the locations, plotting it out. And then lo and behold, not so long after, he robs a bank. He says, you can't do that. You can't admit character evidence. The court says, no, you were talking about robbing a bank. You were planning the location. That is directly linked to the fact that you did, according to the state. So all of the cases they cite have a very direct link. The evidence that they're trying to admit against Mr. Baldwin, it's all propensity. Mr. Baldwin's not a murderer on the 21st because he swore on the 16th. They're going to try to show that. That's highly improper. It should be excluded. Thank you, Your Honor.
May I please report? Your Honor, first, these other acts evidence constitute res justi. This is intrinsic evidence. And I can tell you I'm intimately familiar with the United States versus Riego case because that was my case. Mr. Riego was charged with 4 counts of involuntary manslaughter. And the
Oh, oh, oh. Ooh, that's really bad when the defense is using your case against you. Let's see how this rules. We'll see how good her case was or not.
court allowed the introduction of his prior medical records from about 2 years before the incident happened. So the traffic accident happened on September 7th, 2019. And Mr. Riego was driving on the interstate on a phone call with his wife. And then he unfortunately crashed into the victims and killed 4 people. The court allowed evidence of those medical records and allowed evidence of his application to get his commercial driver's license, where he indicated that there were no medical issues. And also the court noted in allowing this as res gestae or intrinsic evidence, that this evidence goes to the defendant's reckless state of mind. So for involuntary manslaughter under the state statute, as the court knows, the state has to prove that the defendant acted without due caution and circumspection. And so we have to prove criminal negligence, that the defendant willfully disregarded the rights and safety of others. And the uniform jury instruction, and it's cited in the Henley opinion, that the defendant should have known of the danger involved in his or her actions and continued to act. So intrinsic evidence is evidence that is directly connected or provides context to the jury of the charged offense, and it's connected to the factual circumstances. So what the defense wants is for the jury to be, for the state to only be allowed to introduce in a vacuum the moments leading up to October 21st, 2021, when the defendant shot Ms. Hutchins. However, intrinsic evidence allows the introduction of evidence that's inextricably intertwined with the acts that form the charged offense. So I would respectfully submit, Your Honor, that this is, the state has submitted this notice on June 17th as required, putting the defense on notice that these different videos show the defendant acting in a wanton and reckless manner. For example, there are 8 videos, and those are exhibits 61, 62, 63, 67, 68, 72, 74, and 76, where his finger is on the trigger when it shouldn't be. There are some videos, 7 videos that show the defendant sort of horse playing around with guns, exhibits 95, 111 to 115, and 65. Evidence of the defendant using the gun as a pointer, exhibits 91 and 58. These are inextricably intertwined with what he did on October 21st, when he pointed that gun at Ms. Hutchins, cocked the hammer, and pulled the trigger. And so that prior evidence, those other acts evidence, basically put into context what happened on October 21st and established the recklessness mens rea. In the alternative, oh, and there's another issue, Your Honor. So the defense are going to be arguing to the jury, and we've seen the preview, that this gun was modified and that it didn't work. Again, as intrinsic evidence, these videos show on a number of occasions that this gun was working perfectly fine. It had no malfunctions. Every time the defendant fired it, he pulled the trigger. There were no issues. So it is actually relevant to demonstrate that there were no issues with this gun. In the alternative, Your Honor, these other instances of the defendant's conduct are admissible under Rule 404B to show knowledge and to show lack of mistake. Knowledge in that the defendant should have known on October 21st, when he was pointing that gun at Ms. Hutchins, that his conduct was wanton and reckless. And we prove that by the evidence of the other instances where he acted in a wanton and reckless manner as it relates to this gun. And so, and it also shows that there's no mistake. The defense is going to argue, oh, this gun just discharged on its own. I didn't do anything. This is not a mistake. Each time he had his finger on the trigger, previous occasions when he shouldn't have. And so I would respectfully submit that they are admissible as intrinsic or in the alternative under 404B. Thank you.
Any reply?
Yes, Your Honor. 2 points, Your Honor. Number one, the state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. That's propensity evidence. That is not what Reggio allows, not what Coughlin allows, not what Lambert allows. They cannot do that by showing what happened before is an indication of what happened after. There was no, as I said, aha moment connecting state of mind before to state of mind on the 21st. No accident happened. Reggio, the reason state of mind was inextricably linked was because he lied about his medical condition, knowing he couldn't drive. That's the proof. That was inextricable. It was a predicate act. None of these are. On top of that, most of the clips don't show Mr. Baldwin shooting. They show him swearing or putting a gun on the ground or taking a gun when he's lying on the ground and sort of accidentally pointing it. These issues are not what they're trying to show about the 21st. He's not shooting, showing a malfunctioning gun in most of them. They're trying to bring it all in, not to show what happened on the 21st, but to use it as reckless evidence of before and therefore after. She just told you that, Your Honor. I have nothing further.
All right, thank you. You're going to see me looking at my laptop. That's because I took notes on these matters on my laptop. All right, the court rules and reasons. Evidence regarding defendant's handling or firing of the firearm or firearms firing during the filming of Rust are relevant in that they have any tendency to make a fact more probable, to wit that the firearm worked properly during the filming and that defendant Baldwin was not handling the firearm safely. This goes to facts of consequence in this action. Applying the balancing test in which the court may exclude such relevant evidence if probative value is substantially outweighed by unfair prejudice, confusing the issues, etc. The court balancing test does not weigh in favor of defendant. However, any of the videos or any evidence or pictures which relate to Mr. Baldwin not handling or that goes to the defendant's the gun didn't work, and they're showing that it did work because he's shooting videos that show that he's cocking the gun when he doesn't need to cock the gun, goes to the negligent use of a deadly weapon. However, everything else regarding him yelling at the crew or telling people to hurry up, none of that is relevant, and that is propensity evidence. So I think that you all can look at the videos, look at the any of those exhibits and agree which ones meet my ruling. And if you can't do that, then I'll have to help you out. Okay?
Okay. First of all, this lady here, boy, she's all emotional. Oh, she's like her head's just going. She's just really reactive. It'll be fun watching her. Okay. We're going to step away, I think, from the Baldwin trial because we have all day of these motions in limine. I was hoping we'd have a voir dire, and I don't see that yet. So we're going to keep our eye out for the voir dire in the background. However, this is going to get very tedious and very long, and we have lawyers actually covering it. So we're going to step away from that for a minute. So, Ronnie, do y'all want to keep watching it? I mean, we'll keep watching if you want. It's just a lot of in the weeds, and basically, when we're watching the trial, we're going to see what's happening. It is relevant. The judge is already starting her Beverly Bev tactics. So, anyway, we're going to break from that. We're going to keep that going in the background. If anything happens, Miss Kev, let me know. Yeah, but Do y'all remember the trial that we did with Karen Swift and her husband David Swift, where he was charged with killing his wife, and it was all not guilties until the last charge, and then I think it was voluntary manslaughter. Anyway, there were so many charges. They came back as a hung jury. Well, we have some stuff happening, and we're going to watch a little.
Murdering his wife.
Miss Diane, I can throw up captions if you'd like to take a break.
More than a decade ago is seeking a bond reduction after a jury failed to reach a unanimous verdict on murder in his trial. Last month, a jury found David Swift not guilty of the majority of the charges against him, including first-degree premeditated murder and second-degree murder, but they remain deadlocked on the charge of
Why are the captions not coming up? Let me try and do this and get it over here.
voluntary manslaughter. Swift was accused of murdering his then wife, Karen Swift, back in 2011, just weeks after she had filed for divorce. Her car was found with a flat tire about a mile away from their home. Her body was found 6 weeks later, covered in kudzu and abandoned in a cemetery. Now, while we wait for court to begin for that hearing, let's take a listen to how that split verdict played out in court and how the attorneys reacted to the news.
The court will enter a verdict of not guilty as to the charge of first-degree murder. The court will enter the charge of not guilty as to attempted first-degree premeditated murder. The court will also enter a not guilty verdict with respect to second-degree murder. And the court will also enter a not guilty verdict with respect to attempted second-degree murder. The court will enter and declare a mistrial with respect to the charge of voluntary manslaughter.
At Vistaprint, we print everything to show off your brand. So you can print it like...
What's going on here? Really? 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 What the? I hate that. Don't you guys hate that? Don't you hate it when that happens? Because I know I'm in the right channel. Or it must be in their part. Because I'm in my right channel.
Like Simon's Restaurant and outfit your whole...
Sorry about that, guys.
Well, it's disappointing, obviously, that we didn't get to conclude the case. But anytime the jury works as hard as they did in a case like this, I don't think any of us can be disappointed with them. They spent 2 days trying to get a decision. They just couldn't do it. Obviously, we will be back here again. We'll have to make a decision about whether we're going to retry the case. I'll go back, talk with my staff. I'll talk to Mr. Taylor, and we'll make a decision at that point. I do want to thank the jury. They did everything they could possibly do. They did work hard. And as I said, we're disappointed that we didn't get to complete the case one way or the other, but we're still thankful for what they did.
And the judge referenced jurors might be surprised when they see certain evidence was excluded. Is there any avenue to get another look at some of those pre-trial rulings, or is that evidence out for good?
No, it's not out for good. If we have another trial, we would start the whole process over again. I'm sure that the defense would object the same as they did. We would have the same arguments. I'm not sure if there would be a change with that, but we do get an opportunity to try to get some of that back in.
Just for clarity, explain again what the decision of the jury was today and what the next step is.
Yes, the decision of the jury today is they found Mr. Swift not guilty of attempted first-degree premeditated murder. They found him not guilty of second-degree murder, but they were hung on voluntary manslaughter and down.
Can you speak to some of the challenges of working on a case that primarily has circumstantial evidence?
Oh, it's very difficult because we knew going into it, and I think you'd know from my opening statement, that it was going to be circumstantial. It's very difficult because I think juries like to see direct evidence. They like to see DNA, blood, fingerprints. So, it's a uphill climb from the very beginning. So it's always difficult to put those cases together. Well, that was a little bit difficult because we had lost witnesses. We've had two investigators, one who is now deceased, one who is now medically unable to testify. We have witnesses that are no longer available. So the longer the case goes, the more difficult it would be. So we have, it did make the case much more difficult even now to prosecute.
Is that the case?
I'm sorry.
Will you tell the court your intentions of the case at the next hearing?
Yes, on July 2nd, we should have a decision and let the court know at that time. We're going to have a hearing at that time. Right now, Mr. Swift's bond is revoked. There will be a hearing to whether it should be reinstated, and we will have proof and argument at that time why it should not be.
Could you speak to what's going to happen?
Okay, I kind of want to stop here for a second. I think, if I'm not mistaken, that he has decided they did not revoke the bond. He is still under bond. So it's my understanding that instead of putting that financial burden, he went ahead and went into jail. If I'm wrong, let me know. So we have some interesting things going on. I'm also trying to keep an eye out for the Turtle Boy hearings today. They had one this morning. He said, nah, that wasn't a big deal. We have another. Oh, shoot, I should be signing. We have another court hearing this afternoon with Turtle Boy, and we'll see what happens. So I want to show you something. It's interesting. Concerning the Karen Reed trial. Are you ready for this? Dun, 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 dun. At this stage. Okay, are y'all ready? Update on the Karen Reed trial. Drum roll. Jurors voted unanimously. Oh, wrong one. Over here. I'm trying to expand it just a little bit. Okay. This is supposedly the real deal. Where's Peggy? I don't know where Peggy is. Okay. Here's the deal. We have the decisions. Update on Karen Reed. Juror voted unanimously not guilty on the counts 1 and 3. It was a 9-3 for count 2. Okay. We do have a motion that was filed on the 8th. It's an affidavit of Alan Jackson in support of the defendant's motion to dismiss. Law firm on Tuesday, July 2nd. I was contacted by Juror A. The name, identity. Trying to get it just a little bit bigger so I can read it better. It's a little blurry because it's a scanned version. Okay, that should help me out a lot. It's a little better. Go a little bigger. Yay. I'm trying to make it easier for me and those who are visually mature. On Tuesday, July 2nd, 2024, I was contacted by a juror. True name and identity withheld to maintain anonymity based on my conversation with Juror A and the juror's description of who he, she is, where he, she was seated, and certain identifying information, names, and occupation disclosed during the voir dire process. I was able to positively identify the juror he, she was. Juror told me that he, she was seated in seeing inaccurate report about the split among the jurors related to the mistrial that the court declared on the day before. Juror A stated that he, she wished to be respectful of the privacy of the deliberating process, but did wish to inform me of the true results of such process. Juror A indicated that he, she believes it important to disclose such, and then we're done with that. So I need to get the rest of that document. I'm going to try my best. I'm sorry if I dropped out. They are requesting that she all charges for counts 1 and 3 be dismissed because he, i.e. lawyer, has proof. Thanks for being patient with technical difficulties. He, i.e. lawyer, has proof that the count, oh, thank you, that the counts 1 and 3 were not guilty. So I need to pull up what I'm looking for. Trying to pull out the counts of which Miss Karen Reed was charged. And I just love these stupid commercials that pop up every time, and I shouldn't be having them. So let me get all my screens closed. I have a lot of stuff up on screens. I'm trying to get everything out. Karen Reed documents. There we go. I'm trying to find notice of document renewal motions. Anybody in my mods have the document? I need the document, the original charge. Yes, it is. I'm going into Discord, but I'm not finding what I'm looking for. Appeal Commonwealth motion dismiss pretrial. Let's see if it's under the pretrial documents. Let's see if it's in there. Oh my gosh, all the exhibits. Oh no, we don't need that. That's not what I need. But we are trying very hard to find this. Also, one of the things I wanted to talk about real quick with the Karen Reed trial, we have two videos that I want to go over because one of which is, we've talked about them before, is the videos of Paul O'Keefe talking about his brother's death and the trial and his perspective on everything. We watched a video of a friend of John O'Keefe's talk about how he believes that Karen Reed is innocent. We have so much coming out that it's really hard for us to keep up with. So, renewed motion, no dates list. I need the original charge. Is what I'm looking for and I can't find. I know. So, when, oh, thanks, Zach. Zach, you're in. Woohoo! I am trying to find the original charges on Karen Reed, and for some reason, I'm having a brain fart. I'm having a brain fart. Or as my friend used to say, that was pretty rude. It needs to be brain cramp. You know how that goes. It's a brain cramp. Let's do this. Hold on. This is cool. What was Karen Reed charged with? Someone got me hooked up with something cool. Let's see. Oh, Zach! Oh my gosh. Oh my gosh. Thank you, Zach. Oh my gosh. Thank you. Yes. For you who are watching. Oh my gosh. Hold on. Didn't take it. What was the charges against Karen Reed? What happens is people, it doesn't spell the way it should, and it doesn't give me what I want. Thank you so much, Zach. Yes, that was so crazy, y'all. Let's talk about that real quick while I get it. When I got the notification Saturday night, Sunday morning that I could apply for monetization, it said a month and a half wait. I got up this morning and we monetized. It just says multiple. Come on, people. List the charges against Karen Reed, R-E-A-D. Boy, every time I go to find something, I can't find it, and it's starting to really tick me off. Do you not have the jury from Ada form? Okay, here it is. Got it. Got it. The first charge was second-degree manslaughter, allegedly intending to kill or knew she could kill John O'Keefe. Third-degree involuntary manslaughter, acted recklessly with indifference and disregard. Fourth, negligent motor vehicle. Okay, that's not, what they were hung on was manslaughter while operating a motor vehicle while under the influence. Includes two specific allegations: while under the influence with a blood alcohol level greater than 0.08. So, y'all, that's what it was. So what happens now is what they're doing is they're asking that all charges be dropped against her. No more. They can't retry her on what the jury did not find her guilty on. Now they had two lesser inclusive charges. That wasn't a part of it, but the one that they were hung on was the manslaughter operating a motor vehicle, but it was 9-3 is what was hung. So if I was in the prosecution, I would not be at all. I would no way, in any way, shape, or form. Thank you, Miss Kevin. There was no way in any, I wouldn't recharge it with a 9-3 split. If it was 3-9, 9 not guilty, 3 guilty. If it was 3 not guilty to 9 guilty, I would retry the trial. I don't know what's going to happen. It is, Zach, so far good. Hot. How's it in your neck of the woods? Yeah. 9 not guilty, 3 guilty. So that's the way that verdict was melting down. So it's been pretty interesting, y'all. It really has been interesting. Just want to let you know, guys who were questioning, I am safe. I am well. as far as the term of the situation with the weather. It's really hooked east of us. So, okay, so let's do some reading because I've got the document up in front of me now. I am going to be, thanks to a new mod, I'm going to be we're going to be reconfiguring my cables and redoing some things to help make me run just a wee bit smoother. It's really as I grow process here, guys, please understand, we're growing so fast and I am growing in areas I didn't know what to do. I've added additional light to make it a little more balanced. We're having to add an extra computer. I mean, everything is just growing leaps and bounds, and it's a wonderful thing, but we are having a few growing pains. So, Haley Mouse, that isn't telling. Oh, and so we are, come here, Cindy. Good girl. Thank you. So please be patient with us. In probably about another couple of weeks, I'll have this a little more streamlined. It's fabulous. I'm excited. And I thought my learning curve was reaching a pinnacle. Since I here, but my brain feels like I can't absorb another thing. And then there's 5 things I got to learn. So patience. Let's see, Texas is a really big state. I live in Texas, and it took me 7 hours to get to where Ada was. Yeah. And I'm not even across. I'm in the middle of the state, Sensei place. It takes me 8 hours just to get to El Paso. I'll let her answer that, but I'll say she's far east. I'm central in El Paso. It would have taken her about 16 hours. Well, it depends on how she goes. Anyway, back to the case. So, the jury unanimously concluded that Miss Reed is not guilty on counts 1 and 3. What concludes its acquittal is not to be controlled by the form of the action. And I'll put this up. Why am I just doing this? Why don't I put it up? I'll put it up. I'll put it up. Share screen. There we go. And I don't need the interpreter up for this because, well, you know, how can I make this bigger on this end? My thing is, depending on the program, depends on how big it gets. And that's the frustration. That's about as big as I can make it, guys. I don't know how. Let me see if I can click on it and do this. These are the things I've got to learn, and my apologies for those who makes it smaller. It's the best I can do right now. Well, it's about 90 here right now. Okay, let's get to this. Okay. I'm not going to read all the case stuff. What constitutes acquittal is not to be controlled by the form of the actions in question. Must be determined whether the action or actually represents the resolutions correct or not correct. If some or all of the factual elements of the offense charge. Here's attached affidavit by Attorney Jackson that reflects statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty of counts 1 and 3. There was nothing tentative about the jurors' statements. On the contrary, they were definitive in describing the results of the jury's deliberations. Let's go to page 2. And that all 12 of the jurors were in agreement that she was not guilty of such crime. Yannetti, his affidavit is there. It was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose again. I'm reading this for the first time, so please be careful, be patient with me, and I'm dyslexic. See that there was no consideration of murder 2, and Miss Reed should have been acquitted on that count. To hold that this form conclusion did not amount to an acquittal simply because it was not recorded in the verdict form would be to elevate from over substance in a manner prohibited by the foregoing United States Supreme Court. So basically, they're fighting like crazy to get the 2 charges dropped. I'm not going to read all this lawyer stuff. I'm trying to skim through. Absent of the defense constant state of federal double jeopardy protection bar. Basically, they're going to say that if they try her again on same place and stay there down. So basically, what they're saying is if you try this again and you don't drop the charges 1 and 3, you're doing a double jeopardy. The juries did come back not guilty on that fact. End of discussion. That's
Ada.
what.
I'm the voice in the sky, Ada.
Huh? Oh.
Hi, we have breaking news in the Karen Reed case live on Twitter
Go
right
for it.
now. The Norfolk County District Attorney's Office immediately announced plans to retry Karen on the same counts. They look forward to picking a trial date on the 22nd.
Okay, but that's not the judge's order.
No. So we're still waiting. We're going to find out on the 22nd probably what the judge is going to say in response to these motions. Also, I have the motion. We have Ronnie put the motion PDF format for you. So if you want to download the PDF, then you could
I've
probably
already
zoom
read
in
it.
here. Okay.
I got it on the chat GPT.
Oh,
I forgot I had that.
Funny.
See, guys, I'm learning. This is a
So-
learning curve, y'all.
Yep.
I'm going to do this. It's easier for me. She just has to get her face in the center screen.
Oh, yeah. Sorry. But yeah, that just happened.
Okay.
All right. I am out, but I wanted to let you know that that was breaking right now.
Oh, that's okay. When we have breaking news, hop in. All right.
Got it.
That is right. They are going to lose so much harder. Braxton, do you want to hop on? You're more than welcome to. Miss Kevin, can you please see what we can find what's going on with Turtle Boy? It is simply insane. Uh-oh. Oh, I forgot about that. No. Okay, hold on. I got to do a screenshot, y'all. I have a computer. I got a computer guru. And I need to make a screenshot for him. Good God, it's going. Yeah, we're bottoming out. We bottoming out. So what's happening, y'all? I'll educate y'all what's happening. I have this fabulous guy, and he is looking at what is happening to my computer while we're running because it's a great computer. He told me I did really good, but it is struggling in some areas. Okay, you can jump in on voice. Definitely. Welcome, Miss Leah Wells. Welcome. Glad you are here. Y'all are awesome. I just saw your comment, Miss Diane. No smoke? Oh, you're not voiced. Okay, now you're voiced.
I can voice. No, there was no smoke, but there might have been had I not found myself in there.
All is well. All is well. So The Alec Baldwin trial, what's going to start tomorrow is they're going to start jury selection. I don't know if that is actually going to be televised. I don't think it should be, honestly. Um, Truthfully, I think I think putting that up there would be a wrong thing to do. They are live again. Let me see what they're doing. Okay, I'm gonna Okay, they're getting into some fun stuff now. So we're gonna hop back. By the way, BACK looks like this. Right, Miss Diane? Back.
BACK.
Okay, so let's share this screen and let's watch this because it is interesting. In the meantime, at the stage, hello, Mr. Braxton. How you doing?
I am doing good.
We have more breaking news in the Karen Reed case.
Yes.
Breaking Massachusetts. This is Ted Daniels on X, by the way. Breaking Massachusetts State Trooper Michael Proctor has been suspended without pay during the duty status hearing today, pending investigation.
OMG. Are you kidding? I gotta do it.
Wow. We were waiting on that.
Okay.
I think this is not a surprise based on the conduct that we saw and what was brought to light in the trial. I think it's not a surprise at all. We should have expected this. I would have expected it sooner, to be fair.
Right.
But I think they're doing the right thing. I think they're feeling the public pressure. There is a protest happening today also down around the courthouse, I believe. They're doing a peaceful protest, by the way. And it's going to be from 4 to 6. And I'm sure that they are feeling as though their voices are being heard.
It's about time.
I just can't believe that they feel that they can retry on the same charges and get somewhere.
Now that I'm monetized, there's a song that I would have loved to sing. It's something about it's about time.
It's about time. It's about space.
Can't do it now. Monetized.
Oh, wow. Yep. I just saw that. I was looking for Turtle Boy updates, which I've seen nothing.
All right, Mr. Braxton, your humble opinion on this?
I think that they probably had. I think that they had the investigation into him that was really originally that may have just been internal affairs or whatever, where they looked into it at a surface level. They saw it happen on the trial. Then I think they dug deeper.
Mm-hmm.
And I think that they were horrified by what they found.
Mm-hmm.
And they may not have planned to suspend him without pay originally. Like, there may have been some grace given to him. I don't think after their investigation there is. Like, I have a feeling there's a whole lot more in his closet that people now know about.
Well, I think there's a whole lot more that's going to come out, but I will tell you, part of the thing is that I'm not surprised on how this is being handled. Number one, because there's a union. Number two, they have to go through a process because you can't walk up and suspend somebody. I mean, I guess you could if they did certain things, but they have to go through the process. And I think that they are actually going through the process a little faster.
Exactly.
I think that a lot of times it takes longer and it's pleasant. I'm happy to see.
I agree with you, Ronnie. I think that his Turtle Boy's charges should be dropped.
Yeah. I think that especially after the video, I assume all of us have seen it. I don't think Miss Diane has. But he's just in public having dinner and come out of a restaurant and have that group of people. We call them McAbes. What that actually is, the Mick Albert and the I'm tired.
Albert
McCabe's and the Alberts.
Yep.
McCabe. Mick. That.
Yep.
Just so you know, in sign language, when we get a little hand flustered, we'll go, that.
Mhm.
So we have the McCabe's is one family, Alberts is another family. And so when we have both McCabe's and the Alberts behaving inappropriately at the same place at the same time, we call them McAlberts.
Zach is exactly right. That is not the only time that Proctor behaved this way. And we're finding more and more cases. Sandra Birchmore is the first one that I know of that's been getting some good attention, but I'm sure there are more to come that have his fingerprints all over it.
Well, the interesting thing is that it would not surprise me if more than half of that police department does not either one retire early or are removed or rehomed.
I have a feeling that they have
All right, I'm going to step back.
They're going to find a whole lot more in these officers' closets during this investigation. Like, what? Oh.
Why isn't it automatically? It should automatically post. Also, try switching your camera. I can't do that. But anyway, let me take this banner off. I think that's the problem. So, oh my gosh, thank you so much. Sing whatever you want to. This is more than YouTube ad revenue will pay. I don't even know what the ad revenue pays. I was told it's something along the lines of 3 cents for every 1,000 views or something. You know anything about that, Braxton?
I have no idea. They keep that under wraps pretty well.
Yeah.
Like, you have talk about it, but no one knows some actual numbers.
True. Well, I'll take anything. I'm sitting here.
Right.
So, but you said sing whatever I want to sing. I'm kidding. I'm not going to sing right now. Basically, peanuts, unless you're getting millions of views. True. But do you know what? Peanuts adds up.
You know, 100,000 views. It's not a ton of money, but if you're able to get that consistently, you do get better ads. So from what I understand, there are two metrics. It is the amount of views and the consistency of the views. Because advertisers want enough eyes that are consistently seeing it if they're watching it. But if it's one thing sporadically, they're a lot lower tier ads.
Well, I think we're in a good part of this life for me to share this. I went through a journey where, because of prednisone and chemo drugs, gained a lot of weight. And I lost 100 pounds. And then I had to go through another chemo treatment for skin cancer. So it came back all on. And so I have made a commitment to going back and losing that weight again. So I'm going to say, hold me accountable in the sense of, you noticed today a meeting, you saw green, that's avocado. I'm having healthy. I took all the chocolate. Well, I don't have that much chocolate, but peppermint Yorkies are my favorite. But anyway, I have taken all of the bad things out of here and I'm eating healthy. And I am going to report in once a week the weight loss. I'm not going to tell you how much I weigh yet, but I am going to report the weight loss. So I almost thought about starting a group called the court. Well, I don't know, some kind of court weight loss team or something. I don't know.
Have you looked into the keto diet?
Well, that's what I'm doing.
Nice.
Modified because of my dietary restrictions. But yes.
But I lost. Of course, I'm young and a guy, so we lose weight differently. I'm sorry. I am so sorry. But I lost like 30 pounds in a couple months on using keto. And I know. My mom, however, still did lose about 15, 20 pounds. So
weight loss council.
Yes.
Yeah. So I have been trying very hard to be better, and I'm using oat milk for my oat milk creamer. So we're doing good. So, okay, what I'm going to do is put this court back on. Braxton, I'm going to take you off a screen, but you're still in the background. And
awesome.
Favor, private chat me. What do you think is going on? Okay. Oh, really? I have a partner in crime? Wait, partners in crime. That is funny. That is good. That works. Okay. So we're going to start this. I'm going to put it on screen. Here we go. Well, we can all stay like this. Okay. This works. Braxton, you're on vocal still. So you can talk whenever. Oh, gosh, yes.
So where are we in this? Live or behind?
Well,
Okay.
this is kind of behind in the live. They're still live.
Awesome.
What's happening? I think they are. Maybe they ended.
Cool.
They aren't all day. I
They're
think
on
they're
lunch break, I believe.
Yeah. I did not listen to every single motion. I think some of it is just typical court stuff that we don't really care about.
Yeah, I do have to say there are elbow jabs all over the place.
Well, I think they're getting ready to come in because I saw some snarkiness coming up, so I said it here. So let's go.
If I may briefly?
Yes.
Just at the end of the last motion, you noted in passing before we broke that issues with respect to lay opinion testimony would raise relevance concerns or relevance issues. And I just wanted to get some guidance on the court from that because we anticipate, for example, the medic, as I said, camera grip. We also anticipate people testifying that a few of the other actors on set did their own safety checks, even though those actors said they didn't think it to be their duty. And so
the last part of what you just said.
Sure, let me approach, Your Honor, so you can use the lectern so you can hear me better.
Me?
Is that better, Your Honor?
Yes.
Thank you. And so at the end of the last motion, you noted that issues with respect to lay opinion testimony would raise questions of relevance. And it'd be helpful to get Your Honor's guidance on that because we anticipate the medic testifying, the camera grip testifying about issues that, for example, were not reported to Mr. Baldwin, so don't go to his state of mind, or certain witnesses testifying about what a few of the other actors did on the set with respect to checking their guns when those actors themselves said, but it's not an actor's duty. And so we want to make sure that those issues are not introduced, for example, in an opening statement, when ultimately it will be proven, in our view, to be irrelevant to Mr. Baldwin's state of mind, what another actor may or may not have done under the safety guidelines, or what the medic thought about the set but kept in her head and didn't report to anybody. Obviously, that wouldn't relate to Mr. Baldwin's state of mind without the reporting, or at least there's a question about prejudice outweighing the probative value of that when it goes to state of mind. And so it'd be helpful to get your Honor's guidance on that with respect to these issues before opening, at least. We can submit more papers if you'd like, or
No, I don't want that.
I assume not, Your Honor, but that's why I'm raising it here orally versus submitting something to you.
Okay, all right, thank you. Does the state wish to reply?
Just briefly, Your Honor. So part of the defense here is this was Hannah Gutierrez's job. This is Hannah Gutierrez's fault. The truth is, Hannah Gutierrez wasn't doing her job properly, and everybody seemed to notice it except for the defendant. So it's true. We do intend to have witnesses say, I had concerns about the way that firearm safety was being conducted on set. In terms of whether or not it's relevant that other actors perform their own safety checks, I think probably just depends on how the evidence develops. I think my very first meeting with Mr. Nickus, one of the things that he explained to me is that there's a scene in the movie where the actor Travis Fimmel holds his gun to the back of the neck of the child actor. He's got his finger on the trigger and he's got the gun cocked. And Mr. Nickus said, Travis Fimmel would never have done that unless he felt safe with these firearms, unless he thought that these firearms were completely safe. Well, cut to reality now. The truth of the matter is that Travis Fimmel was one of the guys who every single time Hannah Gutierrez handed him a gun, took the gun and dry fired it into the ground more than 6 times to ensure that he tested every single chamber in the gun. So certainly if part of the defense becomes these other people pointed guns at each other and it wasn't a big deal, then obviously it becomes highly relevant that these other actors felt free to do it, because whether it was their obligation under the safety bulletins or not, they understood that that was a smart thing to do, especially when you've got this armorer who doesn't seem to know what she's doing.
All right, thank you. Go ahead.
Just some clarity, Your Honor, because I think it would be helpful both so we can get the court's guidance and so we can understand what kind of case they're putting on if they give an offer of proof of these issues. Because, for example, if the medic comes in and says, I had safety concerns about on set, that's an opinion about the set that wasn't communicated. It's not to say she can't say, I saw Ms. Gutierrez running around, I saw her doing this, she was moving quickly. Those are facts. We're not trying to get out facts unless they turn out to be more prejudicial, they're probative, unconnected to state of mind. But her opinion about the safety of the set, that should not be included. That's irrelevant.
She doesn't get to do opinion. I already ruled that.
Exactly, Your Honor. And so what we just heard from Ms. Morrissey is, well, maybe it's relevant that an actor checked the gun on set in a different way for Mr. Baldwin, or he checked the gun at all. Maybe it's not.
Okay, I got to stop here. I really want to talk about this for a minute. I actually reached out to somebody I know. There's a very famous actor who lives where I live, and thus I have to be very careful not to say who the name of that person is. But I talked to this person. He's played in multiple westerns or movies that have had weapons. I have to be careful now. Monetize. This is so hard, y'all. Oh my God, this is so hard. I'll get used to it. And they are, what they're talking about is this. Many, many, many people. Wait a minute. Zach sent me a DM. Where? Is it? Okay. So what's happened is that he was explaining to me about how it normally works on set when you have a good armor that's been hired, that has plenty of skills, years and years of experience. Most actors do not check the lead shooter at all. When the lead shooter is handed to them and they say it is cold, then they believe it to have no lead in it, no plastic in it. Good girl, since I know. Nothing. That's what they believe. And they've never had a problem. By the way, I think in the last 100 years, this is like the first person to get hurt was with a blank, and a part of it, that blank came out. It wasn't even the lead part. So this is the first persons to lose life at all due to lead leaving the weapon. I'm trying to be so careful. It's so hard, y'all. So anyway, in this situation, it is usually the actors are dealing with a lot of things. And other people have alluded to this, but they're looking over their lines. They got a makeup person touching up their makeup. They got a costume person fiddling with their costumes. They're getting direction from either the director or the assistant director. There's a lot going on, a lot of chaos going on. It's controlled chaos. And then when they're ready to have a scene where a lead shooter is used, the armor comes up and he will either put it in the lead shooter belt, or they will hand them the lead shooter and they will say hot or cold. Cold means there's not a blank or dummy round in it at all. Hot means that there is something in the chambers. And usually the actor should know if they're going to pretend to pull the little metal piece on the lead shooter that expels the lead. Just ASL interpreter can interpret it normal. I can't say it normal. Then they know that that is a blank round. And so, with all that's happened, I'm playing devil's advocate on a lot of this, but I have to say, after having my conversation with this person and after everything I've seen and heard, I don't understand why he's being charged with the same exact degree and level of a charge that the armorer was charged, when it was her responsibility to ensure that nothing would be in the lead shooter, number one. Number two, 99.9999% of the actors stated by this person on scene believe and are told and have the expectation and don't have any reason to believe that there would be a live lead on round. I mean, on the scene, in the studio, wherever they are filming their movie, not one person would have reason to believe that there would be a live lead on scene at all. And then one person I saw an interview that said, "Well, no problem. No problem, Miss Kevin." So the other thing is that you're sitting there, and Kevin, I mean, Braxton, you can hop in at any time. But what the other thing is that someone said, well, if he was to put the lead shooter to, and it was going to be a self-terminating scene, that he would triple check and make sure that there was nothing in the lead shooter. Well, this particular actor said, and I asked him about that, and he said, do you know how many times I've been on scene where we've had something similar to that, and not one person,
And so,
sorry, didn't mean to do that, not one person checked their lead shooter to make sure that there was nothing in it, because then when it was handed to them, they were told it was cold. And a lot of times they use fake ones. but some scenes when the camera is really close, they use real lead shooters, just empty. That's my humble opinion. Braxton, what do you think? Down. And
There
use
was
lead
no
shooter.
safety going on whatsoever.
What'd you say?
There's no safety on this set whatsoever.
No.
Like, I don't trust anything anyone said. Like, how many actors were just happy to go along with whatever was going on? How many of them actually cared about the safety going on? Baldwin didn't.
Well, this was a Class B film, means they didn't have a budget. So they're actors, they're stunt people, and fill-ins, or a lot of them are not nowhere near experienced that should have been.
Yep.
And then even then, the whole cast, the whole crew was grade B.
Yeah.
I believe there is some responsibility that he as a producer and actor should hold. But I want to share something that we may not be, most may not be aware of. And I didn't know if you knew this, Braxton. Many, remember the film crew walked off that morning? Do you remember that? For the lack
Yeah.
of safety? Well, there's this monitoring system that you can sit remotely. You don't have to be right there where they're shooting the film. I got to be careful where they're doing the filming. You're not behind the camera. You can set the camera up and it's just the camera, but you can be off to the side in the back of the room or even out of the building and see what's happening.
Yeah.
All of that equipment left with that crew. So when Helena Hutchins and the other guy, the assistant director, were behind the camera, why were they where the lead shooter was supposed to be directioned? People kept saying, why? Why were they standing there? Why were they not? Because they didn't have a monitor. The only monitor they had was this little itty bitty monitor on the back or side of the camera.
Yeah.
And that's why their bodies were there. Can you imagine if this was a scene where he was supposed to self-terminate? What would have happened?
Yikes.
I understand Helena died, but they found other rounds on set that were live lead. And
Yeah,
so many people could have been hurt. So that's where I have a problem with the issue with the charge that is on Baldwin. Should he be charged to a certain degree? Yeah. He's a producer, he's a skilled actor, there's a list of things. But he shouldn't get the same type of charge of the person who was fully responsible. What is your thought on that?
I don't think it should be the same charge. They'll probably go with lesser included. Like, at the end of the day, we know there's going to be lesser included. So I think they may only find him guilty on at least lesser included for murder or whatever that charge is.
Gotta be careful with that word.
Sorry. With Helena.
Yeah.
With the charge regarding Helena, there we go. I feel like that one may be marked down to lesser included.
I hope so. Only because once again, either the charge that you're charging him stays, you should have charged Hannah Gutierrez Reed or HGR. You should have charged her with a higher thing if you could. It just doesn't fit. The two aren't equal in my eyes. That's where I struggle. But we're going to play video. Braxton, thank you so much for joining me. You're awesome.
Yep.
I'll see you in the background.
Sounds great.
Bye. Okay, here we go. Miss Diane, you good?
So to actually get guidance from Your Honor, so we know what this case looks like when we're going into opening statement, having an offer of proof on these issues, I think will make sure that we don't end up having irrelevant testimony included, that we don't end up in the middle of opening talking about something that the state is or is not going to do with respect to these important evidentiary issues.
All right, so to the extent looking, I don't think I can't remember the people that testified in Hannah Gutierrez, but one was somebody that walked off the job, okay? And I think he has a pending.
Lane Looper, Your Honor, yes.
He did not testify during Gutierrez, Mr. Nichols.
Lane Looper walked off the job.
Well, somebody that was like the head camera guy walked out and looking at Ms. Morris because we were in the case. But so if he were to testify that I left the job because of safety concerns, that cannot just, it has to be related to what you're trying to prove. So it would have to be related to Hannah Gutierrez. I'm not sure where I see, that's off the top of my head that it would have to be related to Hannah Gutierrez and them observing that this armor was doing a sloppy job, and when they observed other armors, just pretty much what they testified to before. But if they're going to say things like nothing that would speak to him as a producer cannot come in.
Understood.
So if you're going to say, look, this person was sloppily handling the weapon and it doesn't relate to Hannah Gutierrez, then that's producer. That's not actor. Am I being clear on that?
I'm a little confused.
Well, I'm trying. I don't know. I don't remember the scene that you used, but let me just say this. So you're saying, that this actor had to check because he didn't trust Hannah Gutierrez. Okay, that's Hannah Gutierrez. Okay, but let's say the shooting, Sarah Zachary. Okay, when she shot, there were two, and Sarah Zachary shot on the ground or something like that. You would have to tie that to Hannah Gutierrez because that's producer issue.
So let me see if I can help out a little bit in terms of narrowing this down. I do not intend to put witnesses on the witness stand and have them say, generally, I felt unsafe on this movie set. I intend to have witnesses say, these are the things that I saw with regard to the handling of firearms that caused me to feel concerned. And in terms of an offer of proof, all Mr. Nickus has to do is just go read the transcripts from the Gutierrez trial that he's been shoving down my throat for the last 5 months, because that's what I'm intending to have the witnesses testify to. This is what I saw, and this made me feel uncomfortable, and it goes directly to the defendant's defense of not my job, she was great. I had no reason to doubt.
Yes, but it has to be related that Hannah Gutierrez's job as an armorer. You can't just say, I felt unsafe because people were screwing around with guns, because that might not be related to Hannah Gutierrez.
I agree with you. It has to be related to Hannah Gutierrez, or it has to be related to Mr. Baldwin's handling of firearms, which is directly relevant. I agree with you, absolutely.
And one clarification there, Your Honor. October 8th, 9th, for example.
Okay, I want to touch base on that. And yes, I need another cup of coffee. Okay, here's me touching base on that. I'm not for or against. I am in the middle on all of this, but I will play devil's advocate, and I'm going to here. It is and was the armorer's job to make sure that all actors and everyone who handled a lead shooter were doing so in a safe manner. It was not Baldwin's responsibility to make sure that an actor 100 yards away was handling his lead shooter appropriately. Baldwin is only responsible for Baldwin. Okay. I saw the way he handled it and I had a heart attack. I am a licensed lead shooter handler. I had to go through tests. I had to go through classes. I grew up around them, and the number one rule, never point a lead shooter where you are not prepared to destroy what's in front of it. She was hired as the expert. I'm getting a little bit of a light headache. She was hired as the expert. It was her responsibility to ensure that everybody on set was handling properly. At any time, if they were not, it was her responsibility to go up and say, let me show you the proper way to handle that. If you can't handle this appropriately, I'm going to have to hand you a plastic lead shooter. But the problem was, not only were they handling it wrong, she was handling them wrong. She had an extended long lead shooter. Uh-oh, we lost your light, my dear. And what's happened is she was holding it and laying her chin on the end of it, or just holding it with it right under her chin. I was like, huh? She herself wasn't handling the lead shooters appropriately. How would then anybody on set be expected to? You will see these videos. The other thing is that she did not make any corrections. Now, there was a phone call I listened to yesterday where she was in jail and she was speaking to somebody. And basically, she said she was having a fit because, yes, you may use it.
You want to split it?
I just had a whole one.
Okay, I'll wrap it.
Okay. So she was having this conversation and talking about a kid actor on set who had a lead shooter in hand and wasn't supposed to have it, and how upset she was. But she did not correct the situation. You, as a boss, the safety expert, the person on scene that's hired to take care of this kind of situation, ignored it. When you ignore it, everybody else is going to ignore it. You set the tone for that situation. It is your responsibility. If an actor sees you go over and warn another actor that there's a problem with the way they're handling the gun, a good lead shooter, sorry, place the lead shooter, then you're not going to do it. It is her responsibility for all of that. The only thing that an actor is responsible for in those situations is themselves. Yes, Baldwin should have known better, but we cannot, and I personally cannot, hold him responsible for anything anybody else did, including the armor. And that's where I'm frustrated with this case, because yes, he's a producer, but they hired people to do jobs, to take care of things, and they took the money. That's my humble opinion. We're moving on.
Example, Mr. Baldwin's not there. If someone testifies on the 8th, I saw Hannah do X and Y and Z, and I felt very unsafe based on what she did, they not only have to connect it to Hannah respectfully, but they also have to connect that to Mr. Baldwin. Because if Mr. Baldwin didn't see it, then this comes back to the imputed producer theory. He must have known safety issues on the set on the 8th, but they haven't demonstrated that, and they have to demonstrate that to have any relevance to his state of mind.
Well, I'd have to hear what it was.
Of course, Your Honor, but that's an example. If a witness comes in and says on the 8th, when Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe, that relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did, she moved real quickly, Mr. Baldwin was there, he saw that, then that's fair game. That's my point.
Well, what you're saying is that the state can only introduce evidence that Mr. Baldwin was aware of, and I'm not sure that's correct.
If they're going to show that there was a safety issue on set with respect to Hannah Gutierrez on October 8th that Mr. Baldwin did not see or know about?
I don't know.
Okay.
Because the other way you could do this is that with respect to, for example, David Halls, and how he said, well, he periodically checked the gun, and I'm not sure whether there was some kind of I don't know how to put this, some understanding about how she was doing things that could be cumulative. I don't know. I would have to figure that out when it's offered. And I'm sorry.
No, the context is going to matter here, Your Honor. I just wanted to flag this issue because seeing the transcript in the Gutierrez trial, we did see the state try to introduce some of this, and we want to make sure it's connected to Mr. Baldwin.
We do not want a trial within a trial.
Precisely.
That's for sure.
Yes, Your Honor.
But we also want the state to be able to address that, their theory that he should have checked the gun.
Understood, Your Honor.
Okay.
Thank you.
I hope that was helpful.
It was.
Okay.
And it'll come up, and we'll ask
Yes,
for more guidance
absolutely.
when it comes up more
All right.
precisely.
Okay.
I think I probably stand here, Your Honor, right? We've got the next in the
Yes,
day
we do.
on
Okay.
inconsistent statements. Is that right?
No. Oh, yes, no, we already did the lay witnesses. This is motion in Amendment 5, previous contradict the state's, let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6, and
there's 7, I believe.
no.
Or 5 and 6, I'm sorry. So
Okay,
we're back
that's
to
all right.
5.
Let's see. So we're on 5. Okay. Defendant Alec Baldwin's motion eliminated to preclude argument and testimony that contradict the state's previous factual assertions. Go ahead.
Thank you, Your Honor. So I'll make this brief.
Sorry. I was just saying this is not an easy thing to do, and that signers usually are 15 on and 15 off. But if I need to hop in and take over, and she can throw me words if I'm needing it, she'll tell me. So if you see me hop on, you know why. Are we in agreement? Okay, here we go.
In the Gutierrez trial, the state made a handful of important statements that relate to what Mr. Baldwin did or did not have an obligation to do, or the cause of the underlying harm. For example, said Hannah Gutierrez Reed is the autonomous decision maker. Or if Hannah Gutierrez Reed had checked the gun again, it wouldn't have made a difference. Or the training or not of Mr. Baldwin with respect to the gun is not why Ms. Hutchins died. It's because of Hannah Gutierrez Reed, and so forth and so on. We put them in the brief, Your Honor. Those statements contradict a number of different elements of how the state has argued this case in the past. And we expect that those will contradict how the state intends to present its case this time. Two things. Number one, the case law is clear that the obligation of the prosecutor is to pursue the truth and not convictions, if there's a difference between them. And so the case law recognizes that it violates due process for a prosecutor to present contradictory theories across two trials that relate to the same matter. Now, they're not bound by the precise theory or the precise factual, underlying theory, legal or otherwise. The cases they cite are cases like Fry, where there are two defendants. The government doesn't know who actually shot the gun and killed the victim. And so it puts on a trial saying this one did and then this one did, because the government doesn't know. Those aren't internally contradictory.
Can I interrupt for a second? Aren't you rehashing what has already been done?
We're not, Your Honor, because the case law is clear. We can use those statements as party admissions. For example, look at the Bradshaw case.
Okay,
That the
just a minute. First of all, that's not in your brief.
It is, Your Honor.
No, just a minute. You're not going to be able to argue what Ms. Morrissey said as a statement of what the prosecutor said in that case. There's a case, I thought this might come up and I should have pulled that case, but Justice Chavez did it, and it's contrary to U.S. Court case or federal court, because it doesn't allow that in.
There are two different issues here. One is, does it violate due process to do it? And the other is, are we allowed to present the state's contradictory statements?
So I already ruled it didn't violate due process.
Right. And so on the second, and that's what the cases say. That's what Your Honor is referring to. In the Bradshaw case that the state cites in its brief, it says, look at Justice Thomas's concurrence. Justice Thomas said the Supreme Court has not ruled on, and he wouldn't support a due process violation. Mm-hmm. But then you have to continue reading that concurrence that the state cites. Justice Thomas says, if the prosecutor makes inconsistent statements, that risks undermining his case, because the defense counsel can present those contradictions to the fact finder, quote unquote, or close enough, to the Thomas concurrence. And in that concurrence, Justice Thomas says, involving two different defendants, agrees with Justice Souter, says the defendant in the second trial can present those contradictory statements that were made by the state in the first trial to the fact finder, and the fact finder can weigh those inconsistencies as it will. The state does not cite, and that's directly from the Thomas concurrence that the state cites. We're not saying due process. We do argue that. We want to preserve that. But we should be able to present, in fact, their own case says we're allowed to present those inconsistencies. On top of that, the state does not cite a single case, not one, that says we're not allowed to present those contradictions in this case. Not a single case. They say it'd be prejudicial. But their statements, clear as day, what they said.
Let me find this case, because it went to this. But okay, I'm listening. All right.
And they say 403, but Your Honor, they don't cite a single case that actually allows them to say X in one trial and then show up in a related trial and say not X or contradicts the X. And we're allowed to present that. That's their own Thomas concurrence. In the U.S. versus Small case, for example, that talks about 403 and prejudice, says extraordinary remedy. They don't cite a single case for it, and they're asking for an extraordinary remedy. And all we're asking for is that the statements that this own prosecution made in this court, as an officer of this court, as Justice Thomas says we're allowed to do, present them to the fact finder here. Thank you, Your Honor.
All right, thank you.
You ready? You want to find the case?
With respect to the introduction of what are they're calling inconsistent theories, the U.S. versus Ganado Negro case addressed that specifically. That some courts recognize that while due process may prevent the prosecution from presenting inherently factually contradictory theories in different trials, there are those circumstances where there are evidentiary disputes about responsibility for a crime, for example, among several defendants. And in the Ganado Negro case, the court specifically recognized where there are cases where there are multiple defendants, as long as the prosecution doesn't present false evidence or factually or facts that are inconsistent, they can present theories that are different. And that's essentially where what the Ganado Negro case held. With regard to the admission of Ms. Morrissey's statements, Your Honor, we would be creating a trial within a trial. We would respectfully ask, now, while the court is correct, federal case law has noted that statements by a prosecutor in previous trials may be admissible as admissions by a party opponent. The state, I would submit to this court, is different, and this court can exclude those statements. This would be essentially Ms. Morrissey having to defend her previous statements. We're going to be doing essentially a trial within a trial, and we'd ask that the court exclude any statements made by Ms. Morrissey. And if I may just have a moment, Your Honor, I think I can pull that case that the court was referencing. But under Ganado Negro, the state should not be bound to the exact same theory of prosecution that it followed in the Gutierrez trial. This is a different trial. The facts are slightly different as they relates to this defendant's culpability. Unless the court has any questions, Your Honor.
No, I want to find that. It's not, it can be dispositive on other issues, but I want to find that case. I should have just pulled it.
Your Honor, if I may?
Yes.
Two things. As a precaution, if Your Honor would like to reserve on the issue, we can take a look at the case. You can hear a few minutes of additional argument after we've read it. That might be prudent, respectfully. Number two, you heard Ms. Johnson say, it's going to be a trial within a trial. It's 3 statements, 4 statements. The state made them. You just heard her say that the case law allows us to introduce the contradiction. She didn't cite a single case saying otherwise. She said it allows that. They've admitted that. Due process aside, that's the Garnegro case that she cites. If they want to present an inconsistent theory, then obviously we reserve and preserve the due process issue. But if they want to raise an inconsistent theory, then by all means, Justice Thomas says they can do that in his view. But you're allowed to show that it's a contradiction from what they said before.
All right, thank you. Well, that doesn't mean the court has to, so we'll take a look at that. You could find that, and it was Justice Chavez. All right. Okay, we're on.
I like to see it when a defendant is actively involved in their case.
Steve?
I like that. Dog lover, I'm gonna address this. There was not 9-3 on all counts. Counts 1 and 3. 100% not guilty. 12 jurors not guilty. Count 2 was the count that was 9-3, and that was the one that involved the alcohol. Just FYI. Okay, here we go. Let me see if I can move this along.
Judge, they don't want you to allow us to bring in anything about Mr. Baldwin being a producer, but what's critical about the OSHA report is the OSHA report says it was the fault of the bosses. It was the fault of the producers. So if the OSHA report gets to be discussed.
By the way, we'll see if this is true or not true. But from what I read and what I understand, is Alec Baldwin was a producer. He did put up some money, but he was a limited producer, meaning it gave him creative freedom. It was about the acting portion. He was not the producers that handled the money, hiring and firing of people. He was more on the creative end of things, and that really can make a difference. Really can.
And we get to hear testimony from Mr. Genoway and Mr. Montoya about the fact that this death was the fault of the producers. Then we absolutely at that point get to point out that he's one of them. And he was in a position where he got to do whatever he wanted because he was a producer. So if the court is going to prevent us from raising the issue of Mr. Baldwin being a producer, and I respect the court's ruling, absolutely, then the OSHA decisions can't be discussed because they go directly to the fact that he's a producer, and that will open up this issue that I've had with Mr. Montoya in the past, where Mr. Montoya came up with this kind of fake notion of Mr. Baldwin's a producer, but he's not really responsible for anything other than creative. And Mr. Montoya came to that conclusion because he never looked at the contract and he just talked to Mr. Baldwin. When you look at the contract, and I put the language in our response, in my motion, he's absolutely a full producer. There are no limitations on his.
Whoa. I have not seen anything about Alec Baldwin and his contract. Mods, if we can get a contract, that would be great. That would be fabulous, Mods, because I would love to see that. That would be awesome. So let's see if we can get it.
Role as a producer. The language in the producer contract says he is expected to fulfill all of the duties traditionally known by movie producers. It doesn't say there's any restriction at all. So we've got some difficulty here because if they want it in, then producer comes in. If it stays out, producer stays out. So I would ask the court to look at it in that way. If OSHA comes in, the fact that he's a producer becomes highly relevant at that point in time. Thank you.
Three quick points, Your Honor. Number one, we've cited cases saying it's admissible. 8038C says if it's a criminal case, there's a factual finding, and it's a legally authorized report, it comes in under the hearsay exception. We've cited cases on that.
We'll do a test later.
Number two, Jorgensen, their expert witness who's going to testify under Your Honor's ruling as to the safety.
He's not an expert witness.
Jorgensen?
No, he's going to just testify about the guidelines. He doesn't get to provide an opinion.
Your Honor, Jorgensen has no factual knowledge of the rest set. What he...
Wait a second. Jorgensen is the guy with the say guidelines, right?
That's right.
So I rule that he gets to testify about the say guidelines, but he doesn't get to provide an opinion about the safety.
Correct, Your Honor. And one of the issues is that, and we may use it or we may not, but when he was asked at his pretrial interview, what did you do to prepare for giving your opinion? He said, well, I didn't talk to anybody, some hearsay. I read the OSHA report a lot because he's an OSHA guy. That's his background. And so to the extent we think it's necessary to raise that, then that would be the limited context. And so ultimately, because it's admissible and because it may relate to their witness, we may have to raise it. And so that's the context in which it could come up. Number three, just for clarity, the report didn't say the producers are responsible. It said Rest Productions LLC, that's one person's company, is the employer, and the employer, not LLC.
Okay, guys. I don't know what's happening. I know that I've not touched anything. It may be her microphone. That's the problem on their end. But if I'm in and out over the video, we'll fix it. Thanks for letting me know.
Alec Baldwin, the employer, is the one that is being fined under that report. And so there's a very big difference between saying Rust Productions is responsible for violating these OSHA rules and saying that Alec Baldwin is a producer and he had a contract with Rust Productions and therefore he's responsible. That's not at all what the report said. So these are not linked in the way that Ms. Morrissey described. Nothing further.
No, Your Honor.
Okay. Court makes the following ruling. I already ruled that producer liability or whatever does not come in. So this OSHA report is specifically prepared by OSHA to go in and investigate whether the employer had any responsibility, and they were in fact fined. If that testimony comes in and by oral and including written, then you have opened the door to producer. And with respect to you saying that the only reason why we may bring it up is because Jorgensen may mention it, Jorgensen's not going to mention it because I already said only safety guidelines. Okay? All right. Okay, so that's granted. I want to keep track of my omnibus order.
So if I understand it correctly, the OSHA report only will come in if the defense brings it up. If the defense brings it up, then they've opened the door. If one of their experts bring it up, they've opened the door. Then the prosecution can bring up the fact that Alec Baldwin was a producer and start that ball rolling. Be careful, defense. Have your witness as well.
Mr. Souza hired Ms. Hutchins. And so Mr. Souza needs to explain all the background about Ms. Hutchins in order to explain his hiring process, which is, of course, completely irrelevant in the first place and an obvious backdoor and not particularly intellectually honest. Then they say, well, the reason we have to explain where she was born and how she grew up is because there's one moment in this case in thousands of pages in which one witness mentions that she speaks Russian to another witness. So in order to understand that, you have to understand where she grew up in Ukraine and all of that, and her childhood and all of that to understand that. And of course, that's also intellectually dishonest. And all you have to say, if you care about making sure this court is and this jury does not, decide this based on emotion and sympathy and the wrong reasons, is you have to say, did she speak Russian? Yes. Did you understand she understood Russian? Yes. You don't have to go into the 30 years of history here. So that's the way to deal with that. In terms of exhibits, it's also very, very simple. They talk about the lapels. I agree with them. The lapels at the scene are relevant. You don't show the positions of the bodies on the ground. It's not relevant. It's not in dispute. It's not a fact in dispute. It doesn't tend to prove anything. I agree with them. The autopsy is relevant, not the photos. The photos don't help anything. The person who's doing the autopsy is more than sufficient. And let me say something else. And this is why I wanted to quickly withdraw the application for the medical records, which is we don't dispute anything about any of this. This is not an issue in this case. You will not hear us cross-examining or questioning the fact that she passed away or the cause. In the other trial in which you presided off, there was at least some testimony, some indicia that they intended to proceed that way. And maybe that had something to do with why so much of that evidence came in. That is not an issue in this trial. It's just not. And so every single time that evidence comes in, it's wholly irrelevant because I've just told the court we're not making an issue of it, and it's extremely prejudicial. It is the most extreme possible weighing of the scales that one could ever have, because it is completely irrelevant, because I'm saying, I agree, she passed away because of this. So, and their real reasons for doing this is obviously exposed.
Okay, so you're sort of combining everything. Why don't you go through each one that you identified?
Sure. The character of the deceased victims I just did. The moment of death and subsequent pain is obviously completely irrelevant. The emotion, they say in here.
Did you say completely relevant?
Irrelevant. They say that the reason that they're eliciting it is to bolster witness credibility. That is a per se improper reason. They say that they say evidence is relevant and it explains a witness's conduct and bolsters. They're using emotional sympathy, drama of something to bolster a witness's credibility. The fact that she suffered might be irrelevant or admissible in a wrongful death case. It's not in a homicide case. It's nothing to do with it. Nothing. And to the idea that they're going to use it so that the witness is upset on a witness stand and saying, and this is how she fell, and her face was pale, and this, and now everybody's upset, and trust me, I saw what I saw about something relevant, is exactly what a court can't allow. It's exactly what a court can't allow. And they did this the entire trial with, and I mentioned this before with the, where is she now? Is she in the medical vac? They ask all of these, why is even one time, the tone of her skin as she falls, why is that possibly relevant to this trial? And they do it with every single witness they did it with. So then you get to the lapel cameras and the autopsy photos. And so I was trying to track this precisely. Again, we agree that the lapels of the scene are relevant, right? You just don't need to show a body on the ground. It's just not necessary. And the autopsy photos are particularly problematic. They don't show, how are they relevant? We could stay here for days and no one could explain to me how the autopsy photos are relevant. They're not. If the court wants to voir dire the medical examiner and say, is it possible for you to explain this without presenting these graphic, vivid depictions of a tragically killed person? They're going to say, of course I can't. Autopsy photos get ruled out all the time, especially in cases like this. This is not, a whodunit where it's like, okay, let's look at this, but I'm saying I didn't do it. This is a tragic accident where two people who are known to each other and no animosity towards each other, this occurred. And so it doesn't have anything to do with the case or anything relevant. And I'm telling the court that we're not making an issue of this. So if the court knows that, unlike in the Hannah Gutierrez retrial, that this is not in dispute, I really don't understand the basis to allow a single witness to do any of that, a single witness, let alone the cumulative every single witness, which is just being done to taint the jury and to try to get the jury to do something on sympathy. Thank you.
Okay, I'm going to say something real quick. We're not going to watch every bit of this because it gets deep in the weeds. My humble opinion, IMHO, I don't believe that autopsy photos should be shown in a case, especially when we know who had the weapon. That's not being disputed. The problem I have with showing it is, number one, it is dramatizing, showboating to me on the part of the prosecution. The jury should have access to those, but I don't think they should be shown in court and out to the public. The jury needs to see it, but I don't think it should also come across YouTube. I think there needs to be respect and decorum, especially for the victim and her families. Yes, I have to be in another town, Mr. Doglover or Miss Doglover, which I have to be in another town tomorrow. I'm setting up my college. I'm going to college. I'm getting a degree in criminal justice, and I have to go set up some things. So I cannot do a watch tomorrow. So you can't see any of the jury or anything. So I'm not going to be showing that. But for me, I struggle with graphic images being shown. I don't think it does any good for anybody to see that. It just traumatizes the family over and over and over again. So when they start putting images up, I have a rule. I will bring the screen down just like, where is it? I will do that. And I will see it. If it's something I feel that is safe, I will pop it back up. but I am not going to sit here and do anything to traumatize. I'm not going to do it. So if you are not, I'm not will be. We do invite you to watch Mr. R.A. He is part of the reason why I am here, and I hope everybody goes over and supports him. I will be listening myself or watching, depending on where I'm at. And I'll throw my support. If there's any craziness, I will go live tomorrow night. Okay. Probably won't have an interpreter. We'll see. I can't have her every day, all day, and all night, as much as I'd love to. But I'll have her as much as possible. Thank you. She or her. I wasn't sure. So please, I don't know. By some of these names, I don't know who's behind them. So thank you so much for clarifying that. Okay, guys. So I think for the moment we're going to go ahead and stop here. I don't think, yeah, they're in lunch and all that. So if you want to watch a more detailed, watch all this, please go to RA. He's fabulous. But I do have to go ahead and start winding this down because I've got to get ready for tomorrow. I've got paperwork to fill out, and my mod and I eventually have to get together. I call her my mod boss. Get together, and we've got to set up all of the memberships for the YouTube channel today, because once you set it, you can't change it. So I've got a lot of work to do. Let me look and see if we have any new news real quick on any of the other cases that's going on and see if there's any more updates. I don't see anything. If we have anything that goes crazy, haywire, anything that pops up with any of the other trials, including Turtle Boy, I'll come back on tonight. So, anybody have any questions? If not, yes. Thank you, Miss Diane. Appreciate you. Love you. You are freaking awesome. And freaking tired. I'm sorry.
Oh, it's fine.
Why don't you explain real quick what normally happens in situations with an interpreter on something like this?
When you have an interpreter, you would have, like, in a courtroom, you would have a team of interpreters. You may have, and depending on the case itself, you may have 2, you may have 3, you may have 4. It just depends on who's being tried, what the case is. And so you just never know, but you will have a switching off of interpreters. Normally it's 15 minutes. It can be 20 and 20 as the case continues on and they're, rehashing everything. And so then it can go to 20 to 20 because it's not new information. See, the thing is that the longer an individual interprets, the higher the mistake ratio or percentage goes. Because, now think about this, I'm listening, I'm hearing it, I'm changing it, I'm producing it. At the same time, I'm listening to it and producing, changing it and producing it. And I still haven't figured out how to do it yet.
They had a woman, I don't know if I told you, I saw this where they had a woman in an MRI machine. And she was a very skilled interpreter, and they put electrodes on, and they did all kinds of tests. So they had her in an MRI machine, and then they did a test with electrodes, and they had her interpreting the same content. And it is about very rare that we use both sides of our brain at the same time for any long period of time. And this is the one case that they said that she, for 45 minutes, used both sides of her brain at one time. So it is very difficult. So I tell people, watch a news broadcast because it's kind of challenging. And you wait 3 seconds and then you start saying verbally exactly what you just heard with a 3-second delay. And do that for as long as you can and figure how long it takes for you to fall apart.
Oh, yeah. Oh, yeah.
Exactly what this is. But the difference is we are not just listening, delaying, regurgitating with our voice. We're listening, changing it to ASL, which is conceptual, and just it's just this. It's just constant. And it's very tiring. So that's why sometimes I always keep something black. And if I need to hop on for her, she can sit and watch me and I can interpret under her correctly. Am I right about that?
Yes.
I can interpret under her in the court situation because I have her with me. I am not a certified interpreter yet. When I get my bachelor's degree, I will go for my national certification, which is higher than state. That means I can interpret anywhere in the US, correct?
Yes.
So she's my mentor. So if you see me pick up my hands and her hands go down, I am giving her a break and I'm practicing. So, dog lover. So would it be more difficult to sign SEE court than ASL?
Any
My the answer.
is more difficult to sign C because you are saying every word that is said. And it's very, very tiring. Can do it because my first learning was signed English for 15 years. And then the next 20 years was ASL.
Yeah. So this is a very high level skilled. People don't realize we're not flapping our hands and they don't realize, well, you don't, I mean, you shouldn't get paid what you get paid. I mean, it's not really that much in consideration of what professionalism is.
The cost to be an interpreter is
outrageous
through the roof.
Yeah.
Same as like with a lawyer. You have to take the workshops, you have the CEUs, you have to pay for the licenses. Different states require different licenses. So, yeah, it's not cheap.
And the other thing is you have to have vast knowledge and education of a lot of different topics because you go into crazy situations. When I was interpreting after I graduated, I went from a GYN appointment, a female appointment, to then a mechanic shop. Then I went to the Social Security Department to help somebody. And then I went to the dump to help train an employee. And then I went and interpreted for a hospital to train an employee in janitorial services.
You could do nuclear physics,
physics, yeah,
medicine in the morning, and deliver a baby at night with everything in the middle.
Yep, it's a lot. So we appreciate you, Miss Diane, and the super chats. Oh, we didn't even tell everybody. We have someone who was real sweet taught me about it, but we have where is it? Did it disappear? Disappeared. Where is it? We have a buy a cup of coffee. Oh, there it is. We have a buyacupofcoffee.com /AdaKay. And my interpreter's going to be getting that.
Oh. Excuse me.
Perfect. I have a coffee sponsor. So I have my coffee, but right now, until I can get her sponsored, I need to find a sponsor for the interpreter. Maybe you can help with that. But until we get something in place, please, please show her some love. The shovel motion doesn't seem pleasant when she just talked about GYN. Okay.
I'm talking about the GYN. I was talking about the janitorial.
See, there's your delay.
Scrubbing the floor.
Yep. Yep. So anyway, well, guys, be blessed. I'll hop on if something happens. We will see you for sure on Wednesday morning. I will have the thumbnail and everything created with the times. Please go and look. Then, if anything should hit the fan tomorrow, I will be remote. I like the way you think, though. Okay. So, with that, we are going to get our lovely music going. Y'all have a great day. I'll see you soon.